Let's try another evidence hypothetical, this time in a criminal context. And for those of you who need to prepare California evidence for a California bar exam, we'll do that as a separate subject. So later on, I'll be posting those videos, and you can check the playlist for California evidence. Right now, what we've got is a hypothetical with 8 points, and they're asking you to analyze, could an objection or a motion to strike have properly been made, and how should the judge have ruled? This is 8 calls that I need to keep track of. There can't be huge calls like there were in the last evidence hypothetical I spotted with you. They have to be briefer. There might be one call that's uglier than the others, but 8 calls, I can guarantee you that a lot of bar candidates did not finish this. And if you got one with this many calls, people would be freaking out. So the first point is, don't freak out. Take it very systematically, allocate your time carefully, and hold yourself to that. I have circled the numbers because I want to keep track of where I'm to address the point. Sometimes it's the question, sometimes it's the answer. What have we got? Dan was charged with aggravated assault on Paul, an off-duty police officer, in a tavern. They've given us a D name for the defendant and a P name for the plaintiff. Well, not plaintiff, but the victim. Aggravated assault, that's a crime. The prosecutor called Paul as the first witness at the criminal trial. So if you hadn't figured out yet that this was criminal and not civil, and that that's important, they highlighted it for you. And we know that this is the prosecutor's case in chief, and Paul is the first witness. Paul testified that he and Dan were at the tavern, and that the incident arose when Dan became irate over their discussion about Dan's ex-girlfriend. Then the following questions were asked and answers given. Look at that, Dan became irate. When they give you a mood word, it's important. It's going to come up and be used in the analysis, maybe more than once as we go on, because his state of mind is important, right? So the first question is, what happened then? The answer is our first call. I went over to Dan and said to him, So I'm immediately thinking I need to analyze hearsay because I've got a witness talking about an out-of-court statement. I went over to Dan and said to him, your ex-girlfriend Gina is living with me now. All right, let's take this systematically. This is the first call. I know that I need to always think about logical relevance, and I'm going to analyze it here, but I'm probably also going to analyze legal relevance because I need to do that at least once. If there's a point later on where it is the issue, then I won't worry about it so much here. But I probably need to analyze legal relevance here. What's the logical relevance of this? It's being offered to show Dan's mood, right? The fact that he was angry, he was irate. And doesn't that make it more likely that he committed an assault? That's the relevance of the evidence. So now when you're analyzing hearsay, it is an out-of-court statement, and I'm going to want to prove that. But is it being offered for its truth? I don't think so. We're not offering this to show that Gina is living with Paul now. We're offering it to show that Dan was angry, and this likely made him angrier and more likely to commit an assault. So I find that it's not hearsay. It's being offered for its effect on the listener, on Dan. And so I'm going to analyze effect on the listener, and that's my big issue. What about the next question? Did Dan say anything? The answer is he said, yeah, and my buddies tell me you're treating her like dirt. Here we have another need to analyze hearsay. What are we offering this one for? What's its logical relevance? It's being offered to show Dan's state of mind, isn't it? Dan says, yeah, and my buddies tell me you're treating her like dirt. We aren't offering it to prove that Paul is treating Gina like dirt. We're offering it to show that Dan is angry. So I analyze hearsay again here. I show that it's an out-of-court statement, but I also show that it's not being offered for its truth. It's being offered to show state of mind of the declarant. Now, could you look at it as double hearsay? Yeah, you could. I doubt that I would have time to do that in answering 8 calls on the bar, but some people will. Is it double hearsay? Paul is saying, Dan said, yeah, my buddies tell me. Paul said, Dan said, yeah, my buddies said. So it would be analyzable as double hearsay. But again, it's really being offered to show state of mind of the declarant. And if you look at it as double hearsay, you could still get it in. And I leave you to that analysis. See if you can think of a reason. Wouldn't it be a party admission by Dan that he's saying, yeah, and I was really angry, and it's showing why he was really angry? Doesn't it constitute a party admission showing that he's more likely to have been extremely angry and committed the assault? So then we get the question in call 3. Is that when he pulled the club out of his pocket? Aha, I think this one is an easy call. I think this is very straightforward. That, I think, is objectionable on 2 grounds. 2 different grounds that would keep that question, that would strike that. One is that it assumes facts not in evidence. Paul is the first witness. I see no thing in this hypothetical that says that the prosecutor has admitted evidence that the defendant pulled a club out of his pocket. So it assumes facts not in evidence, but it also is a leading question on direct. And I don't see that it fits any of the exceptions that say that that would be okay, because generally leading questions are not allowed on direct. So I have 2 ways to object to this question. One, that it's a leading question. It suggests an answer, right? And the other is that it assumes facts not in evidence. So I like that call. I can deal with that fairly quickly and with quite a bit of confidence. So then, the answer is he sure did. Then he just sat there tapping it against the bar. And now, call 4 is the prosecutor's question. Tell the jury everything that happened after that. Well, can't we object to that as calls for a narrative? It's way too broad a question. It calls for a narrative. So look, you can do this. The key is not to panic when you see this many calls. All right, what's next? I said that he was a fine one to be talking. I told him I'd read several police reports where Gina had called the police after he'd beaten her. Well, that's a more complex thing to analyze, isn't it? So the most obvious thing is that it's an answer to an improper question, so we should have a motion to strike the entire. But then look further than that. Look at what's in that response. How about, I said he was a fine one to be talking? Well, that's irrelevant, isn't it? What do we care whether he had a right to talk or not? It's just irrelevant. That statement is hearsay because it was made in the tavern, not in this court, but it's got a lot of prejudicial impact because of the second part of the answer. So that second part, I told him I read several reports. That part, isn't that character evidence? Isn't that trying to convince the jury that this is a bad guy who has assaulted Gina several times? And so we want it in as improper character evidence? Well, that's inadmissible to show that Dan acted in conformity therewith. In a criminal case, the prosecutor may not, in his case in chief, introduce evidence of Dan's bad character. I would want to see this as improper character evidence, and that I would definitely want to analyze. Dan's objection, based on improper character evidence, would be sustained. You could analyze best evidence rule here because he's talking about transcripts, police reports, not transcripts, police reports. So you could analyze best evidence rule. You could analyze whether this is hearsay within hearsay. But if you're going to analyze those, you've got to cover them really, really quickly. Get in there and get out of there because you've got such limited time here. Next, the prosecutor asks, do you believe the substance of those reports? And the answer is, you bet I do. I know Gina to be a truthful person. That is bolstering. It's improper character evidence. It's bolstering, and you can't support a witness's credibility until after it's attacked. Paul is the first witness. Gina's character hasn't been attacked, so this is improper bolstering, and an objection on those grounds should be sustained and the testimony should be stricken. Okay, then we get the question, how did Dan react to this statement about the police reports? The answer, he hit me on the head with the club. And the prosecutor says, what happened next? And now we get to call 7. I heard somebody yell, watch out, he's going to hit you again. That's an out-of-court statement. And it is being offered for its truth, which is that Dan was about to hit Paul again. So it's hearsay. How do we get it in? What would the objection be? Hearsay. What's the exception? Excited utterance. It's also a present sense impression. It's a statement describing or explaining an event while perceiving it. So I have 2 ways out. What about the second part of it? I ducked, but the club hit me on the top of my head. The last thing I remember, I saw a foot kicking at my face. That goes to witness competence. And that's easy to analyze. Show that the witness had direct knowledge of what happened. He actually experienced that. So that part of it would come in because the witness was competent. What about the next call? The answer to what happened then. Dan must have kicked and hit me more after I passed out, because when I came to in the hospital, I had bruises all over my body. That is objectionable because it's speculation. Dan must have kicked me. It's the witness speculating about what happened. And witnesses are not allowed to speculate. So the whole thing should be stricken, except that the testimony about having bruises after he woke up could come in because the witness is competent to testify about that. That is one huge bunch of issues to analyze. 8 calls. This is a 1-hour essay. The key is don't panic. Everybody else in that exam is facing the same 8 calls. If it takes you 15 minutes to issue spot the hypothetical, you've got 45 minutes left and you've got 8 calls. So that's less than 6 minutes a call. It's between 5 and 6 minutes a call. So take a look at which ones are shorter. Keep in mind which ones you can spend a little more time at, and simply jam your way through those calls, but make sure that you keep your eye on the time. I can promise you that a bunch of people who take an exam with an essay like this in it will not finish it. They'll get maybe through call 5 and they won't finish. So if you can budget your time and have the confidence to know that you can do this, and have practiced enough to know that you can do this, then your answer will stand out as a competent one. You don't have to perfectly analyze every issue in detail, but the more issues you can raise, the better. Evidence essays are difficult. They're difficult because they're always racehorses, and most of us who take a bar exam have not spent a lot of time in court dealing with evidence. This doesn't come quickly. It's not second nature. If you did trial practice in law school, you have a leg up on evidence. If you're an attorney taking a bar in another state, you have an even bigger leg up, most of you. But know that most of the people taking the bar exam with you will be facing the same difficulty. And so you can do this. I think for me, the call that I just put the stars next to, call 5, is going to take me the most time. So I'm going to leave myself more time for that one. Yeah, again, help me out by sharing the video with friends. Subscribe to the channel, like the video. Let me know that this is helping so that I do more of these.